Hello, my name is Mike Tesoro and I prepared this presentation entitled Corrupting Competition, US versus Google. And in this presentation I'll be looking at the recent US case filed against Google in January 2023, alleging that Google has engaged in various contraventions of the Sherman Act in relation to ad tech services. And I guess the title there, Corrupting Competition, is the title that I've lifted from the complaint, which is an allegation that the US government makes against Google that they have actually engaged in conduct which is corrupting competition in that market. So a little bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice, Tesoro Legal Consulting, for the last 15 years, and I specialise in competition and consumer law. I also do a bit of consultancy work for CCH and LexisNexis, advising on competition and consumer law. Prior to that, I worked at ACCC for 15 years in a variety of roles, including as a Director of Enforcement. So the outline of the case is I'll set out an overview of the complaint, look at the relevant legislation, outline the background, look at the allegations which the US government has made, then describe the conduct, and there's quite a bit of conduct, so I'll try and explain that as best as I can. Then look at some other antitrust concerns, outline the anti-competitive effects which the US government has alleged, and look at the relief sought, and finish with some commentary. Now, the complaint was filed on 24th of January 2023, and it was the US government and 8 states who sued Google for these alleged breaches of the Sherman Act. And there were 4 alleged breaches in the complaint. The first was an allegation that Google has monopolized the publisher ad server market. The second allegation was in the alternative. It was an allegation that Google monopolized the ad exchange market, or in the alternative attempted to monopolize that market. The third allegation was a monopolization of the advertiser ad network market, and the final allegation was unlawful tying. Now, the relevant legislation is Section 1 and Section 2. So the tying complaint, the 4th allegation, raises Section 1 and Section 2 allegations. And Section 1 is pretty well known to antitrust lawyers. It's a prohibition that's used primarily in relation to collusive conduct, price fixing, market sharing. And there's a very broad section saying that every contract combination in restraint of trade is a felony, is illegal. And obviously there's been a lot of case law that's provided a lot more understanding of what that section means and how it's to be applied. The second provision, Section 2, is probably most like Section 46 in Australia, misuse of market power. And there's 3 things prohibited: attempts by corporations and people to monopolise, to attempt to monopolise, or to conspire to monopolise a market. And that is also a felony subject to very large penalties. So there's 4 allegations of breaches of Section 2 and 1 allegation of a breach of Section 1. Now, the background of the industry, it's quite interesting. The ad tech industry, I think, is largely created by Google, and they developed a number of sophisticated tools to facilitate the matching of publishers with advertisers. And effectively, they run this automated advertising exchange, which is able to run these high-speed auctions, which puts advertisers who wish to advertise digitally on websites together with the relevant website publisher who can publish their advertisement. So it's quite a sophisticated system. And obviously the fact that it's a high-speed system is a very relevant consideration, because these ads need to go up quickly. And there's a diagram from the complaint, which you may have also seen in the ACCC's report into ad tech services. So you have on the right-hand side the buy side, which is the advertisers, and the left-hand side you have the website publishers. And in the middle you've effectively got Google. They operate the ad exchanges, or the ad exchange. They also operate their own publisher ad servers and advertiser ad network. So they're very involved, and the allegation is effectively they monopolise those positions between advertisers and publishers. Now, what the US government has alleged is that the competition in the ad tech space is broken, and that is due to Google. And I like the way the US complaints are quite emotive in the language that they use. This is very different to the Australian statement of claims, which are much more dispassionate. But as you can see there, one industry behemoth, Google, has corrupted legitimate competition. So that's where the title for the talk came from. So corrupted competition in the ad tech industry by engaging in a systematic campaign to seize control of a wide swathe of high-tech tools used by publishers, advertisers, and so on. And having inserted itself into this central position in digital advertising, Google has used anti-competitive, exclusionary, and unlawful means effectively to maintain its monopoly position. And the US government has asserted that the plan that Google implemented was simple but effective and consisted in 2 steps. The first was to neutralize and eliminate competitors in the ad tech space through acquisitions, and secondly, to wield the dominant or market power which it had in those markets to force both publishers and advertisers to use Google products. And they note that whenever Google customers or competitors sought to introduce a new change, an innovation, or a way to get around Google's stranglehold on the industry, Google would swiftly and effectively respond with anti-competitive actions. And they note there that each time a threat has emerged, and probably the classic threat was header bidding, Google used its market power to quash that threat. And as a result, Google achieved and maintained a monopoly in these relevant markets. Further allegations were made that Google has a pervasive conflict of interest because it's in the middle of all these transactions and it has an interest in getting as much money out of both publishers and advertisers. So that raised a bit of a conflict of interest. And they control the technology used by nearly every major website publisher. They also own all the leading tools used by advertisers to buy the advertising space, and they operate the largest ad exchange to match publishers and advertisers. And I think it was interesting, some of the documents which the US government had access to for their complaint, which are quite revealing, and there's scattered throughout the complaint. But one of the classic quotes is this one in relation to the power of Google in this sector, and it's an advertising executive from Google commenting, "Is there a deeper issue with us owning the platform, the exchange, and a huge network? The analogy would be if Goldman or Citibank owned the New York Stock Exchange." So it's sort of a recognition that they own all the bits of the relevant infrastructure, and obviously they've got significant conflicts of interest. So there's a recognition of the power which Google has in these markets, likening it to a merchant bank owning the stock exchange on which they trade. Now, the alleged detriments, there's quite a lot of them, and I've picked them out of the complaint. So I'll run through them, but slightly repetitive, some of them. But the first one is deploying opaque rules that benefit Google and harm rivals, dictating how advertising is sold and the terms on which it can be sold, disadvantaging website publishers and advertisers, so disadvantaging both sets of customers, funneling more transactions to its own products, extracting inflated fees, raising barriers to entry, forcing competitors out of the market, dissuading new entry, leaving the few remaining ad tech competitors marginalised and unfairly disadvantaged, thwarting meaningful competition, deterring innovation, which is interesting, the allegation that Google has actually stood in the way of innovation and more efficient products and services, taken super competitive profits and prevented the free market from functioning fairly. That's quite an array of alleged detriments. The government's also asserted that the alleged harm arising from the conduct is clear. Web creators earn less money for their advertising space than they should in a competitive market. Advertisers pay more for their advertisements than they should in a competitive market. Furthermore, they've sort of drawn this idea that the conduct of Google just doesn't hurt publishers and advertisers, but actually flows through to the broader community. They say the conduct hurts all of us because publishers who can't make as much money as they should from the advertisements are having to try to raise money from other sources, such as subscriptions, paywalls, alternative forms of monetization. So they're saying that that flows through to consumers. And then they draw the point out that the margins which Google are making are excessive. So they're saying it's troubling that at least 30 cents of the advertising dollar through digital advertising effectively goes to Google, which, when you think about it, it's a very big margin because Google's really occupying this intermediary role. They're between the publisher and the advertiser, and they're facilitating the transaction. And usually intermediaries of that nature would get a return, a commission, maybe 2 or 3%, but you wouldn't expect them to be generating a 30% return. So in the complaint, the US government has alleged 10 different bits of conduct which all combine to make out the allegations that Google has monopolized various markets. So I'll run through them all and then go through them in a bit more detail. The first is that various acquisitions by Google of DoubleClick and ADX have been used to pursue the goal of dominance. Google has restricted the access to advertiser demand through ADX. So there's a lot of allegations of exclusive, dealing conduct in relation to ADX, restricting effective real-time access to ADX through the DoubleClick platform, introducing limitations through this idea of dynamic allocation bidding techniques, providing their own program with the last look auction advantage, so that's a self-preferencing type allegation. A further acquisition of AdMeld, which was a leading yield management technology, and effectively preventing it from being used by publishers. The Project Bell, which lowered bids for advertising space. Also the deployment of this dynamic revenue share concept, which again was to manipulate auction bids. The use of Project Poirot to thwart the competitive threat posed by header bidding, and a lot of the things that were done by Google seem to be aimed at stopping this header bidding, which I'll describe a bit later on. And then finally the introduction of so-called unified pricing rules, which took away the publisher's power to use rival ad exchanges. So it's quite a comprehensive list of conduct which the government has alleged Google engaged in, and this is over a number of years. This all didn't happen in 1 year. This effectively happened from about 2008 to 2019. Now, the background's important because I think very early on Google realized that it had a very profitable search advertising business, which it initially launched as Google Ads and then called AdWords. And the allegation by the government is that Google devised a plan to build a moat around this emerging technology and market because it knew it was going to be profitable and wanted to protect it from competition. So it's taking a very far-sighted view on the need to protect this market. And what they did initially was sort of develop their own ad tech tool with publisher ad service that publishers could use. Now the problem, this leads to the first of the conduct issues, but the problem with Google's own ad server was that it wasn't getting a lot of traction in the market. So what it sought to do was acquire the leading ad tech firm, which was DoubleClick, back in 2008. So it acquired DoubleClick for $3 billion back in 2008, and thus acquired the leading publisher ad server, which had a 60% market share. At the same time, it acquired AdX, which is a nascent ad exchange, which gave it digital advertising space, which could be auctioned. So effectively, it bought businesses on both sides of the transaction, a publisher ad server and an ad exchange. Now, those mergers were flagged through by the regulators, so there was no concern that they lessen competition. The allegation here is that Google has used those two businesses to achieve and entrench a monopoly. The second one relates to the restriction on Google Ads advertiser demand. So obviously Google Ads advertiser demand is quite significant, and what they sought to do was to limit that demand to their own AdX product. And the key thing here is that ad servers, publisher ad servers, are very sticky products. Many publishers rarely switch, and there's that pretty dramatic quote there by the former CEO of DoubleClick where he says, "Nothing has such high switching costs as publisher ad servers. It takes an act of God to switch away from one of those." So effectively, they sought to lock as many publishers as possible into DoubleClick to reinforce the stickiness of the product and forge this exclusive link between Google Ads and DoubleClick through the AdX exchange. And as you see at the bottom there, publishers wanted to access exclusive Google Ads advertising demand. They had to use Google's publisher ad server, DoubleClick, and ad exchange AdX, rather than competitors. The third one is this restriction on real-time access. And this is effectively that if you wanted real-time access to bids for various advertisements, you had to use AdX and DoubleClick exclusively. However, if you didn't use those products exclusively, you wouldn't have access to this real-time bids. Rather, you'd be relegated to selling impressions to AdX at a lower price, at a floor price based on historical average prices. So you'd be locked out of the more lucrative real-time bids if you didn't use AdX exclusively. And as you can see, the 2018 Google presentation bluntly noted, DoubleClick is the only way to access AdX as a publisher. And the comment there at the end, by limiting Google Ads demand to AdX ad exchange and limiting real-time access to the ad exchange to publishers using Google's publisher and server, Google compelled publishers to adopt its ad server for effective access to Google Ads demand. So again, they're squeezing demand away from competing providers of these services. The fourth one was this limitation on dynamic allocation bidding techniques. And dynamic allocation was this means by which Google manipulated publisher ad servers to give AdX, again, the opportunity to buy inventory before it was offered to other exchanges. So it got a first look at various inventory and was able to buy it. And as you note there, it was able to do that at artificially low prices. And it says there that Google programmed DoubleClick, its publisher ad server, to prevent publishers from offering preferential terms to other ad exchanges or allowing these exchanges to operate in the same way with DoubleClick. So some publishers would set terms which gave other publisher ad servers some access to their demand. However, that was effectively squeezed out by Google in the way that it programmed DoubleClick. So a lot of different methods to try and force publishers and advertisers not to use Google competing products. The next one is this last look advantage, and this was effectively in relation to header bidding. What occurred was that publishers were inserting some computer code in order to effectively get around Google's system, and that code would trigger a real-time auction among exchanges before the web page called the publisher ad server. And the way that Google responded to this was to reconfigure DoubleClick to give themselves an opportunity to win that auction. So effectively somebody would bid for some inventory, and before the auction would close, Google would be offered a chance to beat the price and therefore win this quite lucrative inventory. So again, it's an example of giving self-preference to its own operations through the design of DoubleClick. The next one was Google's acquisition of AdMeld to stop access to yield management. So yield management was something that was important for various publishers because they could therefore work out how their sale of advertising space was progressing, whether it was generating sufficient revenues for them. And the leading provider of that service in 2011 was AdMeld. And so I guess the allegation is that customers having access to this yield management technology was not beneficial for Google. People would spend the money more wisely, I guess. So it actually acquired the business and folded some of the functionality into its existing products and then shut down its operations. And it's noted there that shortly after that, Google changed the AdX contract terms to prohibit publishers from using any other platform, such as any other yield manager, that would effectively force AdX to compete in real time with other ad exchanges. So this seems to be an exclusionary type of conduct engaged in by Google. This one's Project Bell, which was a project which effectively prevented or was aimed at preventing publishers from partnering with rival sources of advertising demand. So what publishers were doing was giving other competing providers a first look access to their inventory, and when Google found out about this conduct, they responded by significantly reducing their bids for such inventory and reduced it by about 20%. So this was like I guess a punishment for publishers who were seeking to work with their competitors to undermine Google's power in the market. And as it says there, according to Google's documents, Google explicitly warned publishers that utilizing this innovation, first call technology, from rivals would cause publisher yield to drop 20 to 30%, or basically profits to drop 20 to 30%. The next one was this dynamic revenue share, which it is alleged was a plan to push more high value transactions through the Google Ad Exchange. And the US government's claimed that Google did not just simply reduce its publisher fees, rather it used competitive data which it obtained through its publisher ad server monopoly to adjust its fees in order to win competitive transactions. So effectively it's using information which is obtained through its monopoly position in the ad tech market to benefit its own operations, to therefore preserve and increase margins, revenues and profits. And as you can see there, Google was again able to cherry pick the most valuable transactions out of the hands of rival ad exchanges. And the implications of that was it sabotaged the ability of the competitors to build the scale that they needed to actually provide strong competition to Google. So again, it's a way of damaging competitors to reduce their ability to compete with Google. The ninth was Project Poirot, and there's a lot of interesting titles for different projects that are undertaken by Google. And effectively, this was a way of dealing with some of the problems arising from header bidding. So header bidding was, as I mentioned earlier, a way that various publishers try to get around Google's systems, and it involved the insertion of code which would direct bidding towards other ad servers. And the way Google responded to this was to just shift transactions away from any ad exchanges which were using header bidding. And they allegedly artificially manipulated the bids sent to rival ad exchanges so that AdX could win those transactions more often, and that often was done despite the fact that it hurt their advertising customers. And the final one was the unified pricing rules, and this was again to deal with the existential threat posed by header bidding. So effectively they decided to reconfigure DoubleClick to impose what they described there as competition stifling unified pricing rules. And these rules were effectively to ban the use by publishers of price floors, which gave rival exchanges access to inventory. And as you can see at the bottom there, unified pricing rules were the culmination of Google's work to stop publishers from using ad exchange specific or buyer specific price floors to steer transactions to rival ad exchanges. So again, by changing the rules and introducing unified pricing rules, Google was seeking to impact its competitors and reduce the number of transactions that they had access to. So that's quite a comprehensive list of different conduct which the government has alleged Google engaged in over a period of about 10 or 11 years, from 2008, from the first acquisition, to 2019. There was also this tying type arrangement that there was an agreement entered into between Google and Facebook, and as you can see, the very top brass of those organisations were involved, and they entered into a network bidding agreement. And the way this has been presented in the complaint is effectively Google were a bit worried about Facebook entering the market as a competitor. So they decided to enter in a deal with Facebook with particular terms, including a contractual promise not to have a last look at any of their inventory and direct payment of money to publishers, which ensured that Facebook will continue having this direct relationship with their publishers. And the quid pro quo for that arrangement was that Facebook committed to a minimum annual spend on open bidding and was incentivized through various tiered volume discounts to shift its spend to open bidding and away from competing header bidding avenues. So effectively an agreement by the two to, cooperate and move a significant amount of business away from competing companies to Google. Now, it's interesting that at one stage the plan was to remove various issues in relation to AdX, and they were talking about removing and eliminating the relevant tag entirely in 2019. However, in the complaint it says that Google paused that particular project because of the antitrust focus on their business, and they realized that if they did this pretty big change to eliminate the tag, that there might be some complaints by antitrust authorities. So they didn't keep the ADX Direct tag because it was a competitive product offer. Rather, and this was in their actual documents, they kept it merely as a concept for antitrust, or something Google's antitrust lawyers would claim offers rival ad servers some remote chance of competing on the merits with Google's ad server. So it's almost like by maintaining this particular ADX Direct tag, they were able to say, well, we haven't totally excluded competition by our rivals from the market. So these are the anti-competitive effects which the US government has alleged arises from Google's conduct. Firstly, they say again that the conduct has corrupted the competitive process by which both publishers and advertisers select and use these ad tech tools. They've also undermined the ability of both publishers and advertisers to make optimal matches for advertising inventory. So they're not achieving competitive outcomes through using these services. Google has also interfered with the attempts by rivals to partner with various customers. And as you can see from the things I discussed earlier, there are a lot of ways of preventing both advertisers and publishers from partnering with competing ad exchanges. And obviously that limited the competitive benefits that would flow from these innovations in the market. And they allege that instead of fostering a competitive, innovative market, Google has sought to wield its market power to dictate terms, and ensuring those terms advanced Google's anti-competitive ends and bottom line. And so they're acting often against the client's best interests. They also claim that the anti-competitive scheme spans nearly 2 decades. So it continued from about 2010 to the current time. And the flywheel effects of even the earliest conduct are lasting, enabling and amplifying the impact of subsequent conduct and setting in motion Google's march to an ever-increasing dominant position across the ad tech industry that persists today. So it's a very entrenched monopoly which is causing significant detriment, super competitive pricing, inefficient outcomes. Google has distorted the competitive market forces that would otherwise operate in an efficient market. And also Google has sought to preserve its dominant position at all levels in the ad tech stack and allowed them to generate these super competitive profits, 30 cents in the dollar, advertising dollar. So the relief being sought by the US government is a decree of contravention. So effectively what we would see is a declaration that there's been a contravention or contraventions of the Sherman Act, damages, injunctions, and probably the most significant remedy is divestiture, which is spelled out in the complaint as follows: an order that Google divest at a minimum the Google Ad Manager suite, including both Google's publisher and server DoubleClick and Google's Ad Exchange ADX, along with any additional structural relief. So effectively that the ad tech business be divested from Google more broadly. So that's a very significant remedy being sought by the government. It's a bit of commentary. I guess it's a very compelling narrative of what Google's been up to. Reading through the complaint, you see year by year various challenges arising and Google's competitive response or anti-competitive response. And there's a lot of references to documents which seem to support the government's case. So they have a theory of why Google was acting in the way it did, and there are internal documents which seem to support that view, which is always not good for a company when their senior execs are saying exactly what the government is alleging was the case. Ultimately, the question is whether they're going to have enough evidence to establish their case, particularly whether the relevant markets are considered to be separate markets for the purposes of the Sherman Act. So that's not entirely clear, and there's going to be a bit of an uphill battle to establish each of those 3 markets. There A real question as to whether other jurisdictions are going to take on a similar case or whether just leave it to the US. But clearly, this conduct has global impact, and it clearly would have had impact on Australian publishers and Australian advertisers. So you'd think that there'd be a basis for maybe some action being taken in other jurisdictions, including Australia. And it would be interesting to see how the conduct that's been alleged in this case would fit under Section 46 of our Act, and whether it would be easier or harder to establish than the case which is sought to be run in the US. Be interesting how Google responds. I think it may seek to provide some undertakings. It's done that, and a lot of the digital platforms have sought to address competition concerns by offering various undertakings or changes to the way it's operating. The statement issued by Google following the case being announced was not indicative of any desire to offer undertakings, but ultimately they're a commercial operation and they're quite pragmatic, and it might be interesting to see if they're genuinely concerned about a divestiture, whether they actually offer some remedy like that. Divestiture remedy is a very significant remedy. It's almost like saying that there has to be a new company operating the ad tech business, but you'd think that there'd be a need to cut the ad tech business into two to separate the parts of the business which are on the publisher side and those which are on the advertiser side, because the conflict of interest will remain unless the business is divested and cut into two separate parts. Arguably, there should be maybe a third business that runs the ad exchange in the middle as well, because that's like the infrastructure or the equivalent of the stock exchange. So it's interesting how the divestiture remedy, if the government is successful, would play out in practice. And the final thing I noticed was it was a jury trial that's been sought by the US government. That's interesting to me, because the concepts here are going to be quite complicated and difficult, and you think that maybe a specialist judge would have a better chance of working out all the issues and coming to a conclusion. But I guess if there is a jury trial, it's going to be a very long drawn out trial. There's going to be a lot of need to fully explain all these concepts to the members of the jury. So that's all I had. It's a difficult case to sort of summarize. A lot in it. It's about complaint's about 155 pages. So I've sought to draw out the main issues from it, and it's somewhat repetitive because the same conduct is seen as breaching various, or alleged to breach different provisions of the, or different result in contraventions in different markets. So there's a little bit of repetition in the complaint. So what I sought to do is to draw out the common elements across all the allegations. So hopefully that's been helpful. If you have any questions, feel free to give me a call or send me an email. Bye bye.